Good evening and welcome to the October 29th, 2018 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum this evening, and I'm now going to do a roll call. Gentlemen, would like to state your names?
Rick Welch.
Len Sorelli.
Joanne Stinson. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you aren't able to see or hear. The board works from a published agenda and will consider tonight's items in the following order. The call to order, which we're doing. The new business is a request for reconsideration of the October 1st, 2018 decision to deny the appeal by Jennifer and Ronald Finney et al. And then Code Enforcement Officer communications and adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinance or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision, and that's 45 days from the original October 1st decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, to sign the speaker sheet, state their name, address, and affiliation with the application, which would be for, oppose, or neutral. All persons speaking shall address all remarks or questions to the chair. The meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. And the first matter that we just need to make sure of with this request for reconsideration is that in Shoreland Zoning Ordinances Section 16G, Appeals Number 5, Reconsideration, that the Board of Appeals may reconsider any decision within 45 days of its prior decision. A request to the board to reconsider a decision must be filed within 10 days of the decision that is to be reconsidered. Vote to reconsider and the action taken on that reconsideration must occur and be completed within 45 days of the date of the vote of the original decision. The board may conduct additional hearings and receive additional evidence and testimony. So our decision was October 1st. I have the date of the request for reconsideration of October 11th. Mary, can you confirm it was filed?
It was received in the town office October 11th at approximately 3:45 p.m.
Great. Okay. That's good with that? Okay, so with that, the normal process would be, unless Attorney Katsifigas has any otherwise different suggestions, would be to allow a presentation. David Murch submitted this request, so he may present the request to reconsider. Then we can have questions. We can have comments by those opposing, any rebuttal statements, last questions or comments, and then the public comment would be closed. And I want to stress this evening, this is not a new hearing. This is to decide whether we will accept the request for reconsideration of the October 1st decision.
Right.
Okay.
I think just to clarify even further, I think you've done a good job. But just to make absolutely sure people understand, there were some documents that were submitted. The question is not the value of those documents and what they mean. The question is, why should the board grant reconsideration? Well, what is it that's being submitted? Why should it give reconsideration? Because that's something that is a matter of deference, the board basically can determine, and has free rein to determine whether this is something they wish to accept. Usually it's done and accepted when, in instances where a party couldn't have submitted the information before, it didn't exist, it wasn't known, we didn't know it would be relevant to the board's discussion. And so I think that's basically the framework, something that the party couldn't have been expected to provide, that wasn't available then, that's new, or that there was some egregious error that the board committed that has to be brought to its attention. That's the sort of standard where boards would act to reconsider. One other thing, any member of the board may bring a motion to reconsider if you wish to do that. The question is, do you want to reconsider, and then we'll talk about the actual merits if you go that route.
Okay.
Thank you.
Very good.
Well, there is some stuff on there, but if we can get it up and running, that'd be great. Otherwise, let's not.
It's ready to go, but I'll have to come out if you're gonna
Okay.
do it. Are you gonna speak first?
Yeah, I guess. So, sorry. So, good evening. My name is David Murch. I submitted the request for reconsideration. I am one of the original aggrieved parties of the original appeal. So, I did put together a statement. It's just far easier for me to read it than to try and memorize something and say it. So, I'm just going to go ahead and read what I've prepared, and I do have copies for you subsequent. So, the aggrieved parties for appeal of CEO permit number 2018-041 for tax map 47 lot 20A do respectively request that the Board of Appeals reconsider its October 1, 2018 decision to deny that appeal. The aggrieved parties represent 16 property owners, co-owners, and for 14 property lots within the town of Raymond. For this October 29 meeting, our focus is specific on the 4 following items that we find to be the most egregious. 1, we believe there's an apparent violation of state law by the town of Raymond. Secondly, we believe that there is 1 apparent violation of local law by the town of Raymond. We believe that there is an example of gross misrepresentation by the property owner and contractor in failing to disclose relevant information on the condition of the proposed mobile home. As a result, the CEO was unable to make a valid and informed decision on whether or not the proposed mobile home was appropriate to be brought onto the lot based on its age, condition, and prior modifications made outside of the town of Raymond. In short, the building permit was issued for a mobile home, which in reality did not meet the CEO's original expectations for which the building permit was issued. And finally, we believe there was incorrect procedure during the October 2nd, 2018 ZBA meeting with regards to the board's non-consideration of the HHE 200 subsurface wastewater disposal system application. So a few details. Maine revised statutes, specifically Title 30A, Section 4103, permits item 3C, expressly prohibit the issuance of a permit for the installation of a mobile home previously installed in another municipality until the mobile home owner provides proof of payment of all property taxes on that mobile home in the municipality where the home was formerly located. When building permit 2018-4041 was issued on June 6, 2018 by the town of Raymond, this proof of payment information had not been provided to the CEO. As a result, the building permit should not have been issued on that date, and the town of Raymond was in violation of Maine revised statutes. Number 2, town of Raymond's land use ordinance expressly prohibits the issuance of a building permit until the road commissioner or Maine Department of Transportation has issued a driveway permit. For the pre-existing driveway proposed for use to access map 47 lot 20A, The lot owner, Tammy Knights, does not own the section of property that connects the public road, Canal Road, to the pre-existing driveway that is located on her property. At the July 30, 2018 ZBA meeting, Tammy Knights and David Knights both admitted that this section of property was not owned by Tammy or David's. As such, the property owner does not have a valid driveway to access that lot. When building permit 2018-041 was issued on June 6, 2018, the property owner would have been required to have a driveway permit that accounted for legal lot access from Canal Road directly onto her property, but she did not. As such, the building permit should not have been issued on the date, and the town of Raymond was in violation of its land use ordinance. When building permit 2018-041 was issued on June 6, 2018 by the town of Raymond, neither the property owner, Tammy Knights, nor the contractor, David Knights, had disclosed that the proposed mobile home had been significantly updated both on the outside and on the inside. This information was not disclosed to the town of Raymond CEO until the ZBA meeting on July 30, 2018, nearly 2 months after the building permit had been issued, at which time Tammy Knights then revealed the information about the updates during her public comments. When a mobile home is purchased from a retailer, it must be certified to meet HUD code. If alterations are made to a mobile home that do not comply with HUD code, then the mobile home cannot be sold or offered for sale by a retailer. However, the proposed mobile home for Lot 20A has been purchased through private sale. This and the fact that it has been significantly updated both on the inside and on the outside indicates that the proposed mobile home would need to be recertified to ensure it meets HUD code, or more specifically, the National Manufactured Housing Construction and Safety Standards Act of 1974.
Chairperson, it's my understanding that we have to stick to the points that were submitted. Do we have to get into these other things at this point?
Oh, it's a valid question. We only had 2 points on our request.
That's true, and I recall that the HUD code issues were raised in the materials that this board found were not appropriate to be accepted at the last meeting.
That's right.
So it's up to the board to exercise its discretion to limit the appellant to the argument of why this board should grant reconsideration.
I make a motion to limit it to these facts.
I second. All those in favor? Okay, Mr. Murch, just point of order, if you'd keep it to the information that was submitted to us under this request.
I guess to summarize then, under Maine Department of Economic and Community, Office of Community Development, Code Enforcement Officer, CEO, is defined under 30A, Section 4451, as a person employed by a municipality to enforce all enabling state laws and local ordinances in the following areas: shoreline zoning, land use regulation, internal plumbing, subsurface wastewater disposal, and building standards. In short, the CEO helps to ensure the laws and safety of the town's residents and visitors. With this appeal and the subsequent request for reconsideration, the board in their de novo capacity now has been given that responsibility for the same. We, the aggrieved parties, have never felt that our appeal was a frivolous one. In fact, one board member voted in favor of our appeal. On October 1, 2018, that decision included 4 conditions of approval, which one can argue is an indication that the building permit should never have been issued in the first place. In that decision, it was also written that the Board of Appeals is aware that under state law, it cannot discriminate against newer mobile homes, such as Type 1 manufactured housing, if it meets HUD code. We have evidence that clearly the mobile home placed on Lot 28 does not meet HUD code. For the October 1, 2018 meeting, we had hoped to submit additional information in light of what we now know. If the board does not approve our reconsideration request, if the board does approve our reconsideration request, we will want to introduce all materials that were previously filed either by myself, David Murch, or by Gary Vogel, as well as the potential for additional relevant evidence and testimony. We will be relying on all of that information presented to be put part of the record. It is my hope, as well as the hope of at least 15 other Raymond property owners and co-owners, that the Board of Appeals will indeed vote to reconsider their October 1, 2018 decision in order to ensure that due process was clearly achieved, and also to confirm that the town of Raymond acted both properly, safely, and legally when it issued building permit 2018-031 on June 6, 2018.
questions? I do have a question. Are any of these new issues that were not available to you to bring up at your original appeal on, what's that, back in July 30th?
I was presenting some of that, but you motioned me out of that, so. The other items they were not available to us as part of the public records. So in terms of them providing property tax information.
No, but you brought us tonight two things, and I'm gonna stick to those, two issues. I'm not gonna get into those issues, but regarding those issues that you presented to us for this request, was there some reason you couldn't know that there was a potential driveway issue? I think that was already brought before us, and you could not know that it was a requirement to show that taxes have been paid previously in another town, wherever this was coming from.
At the original meeting, it was under our understanding that it was sales tax at that time and for a newer mobile home. Therefore, we didn't present anything because we knew it was not a newer mobile home. It wasn't until subsequent that we were able to determine it was regards to property taxes. In terms of the actual driveway itself, we were aware and tried to present information in that regard, but it seemed to be that it wasn't heard in terms of the fact that there was no legal property access or driveway access onto that lot.
Okay. Thank you. Are there any other questions for Mr. Murch of anyone who's directly impacted by this? Okay, thank you.
Did you want copies of this document?
I'm fine.
Okay.
Thank you.
I would like to have a copy to put in the record. The
Very
official
good.
record. Yes, no?
Of what he read, yes,
Yes.
but not the whole
No.
thing.
Yeah.
Just the
You're not
portion that he read.
Just the
Okay.
portion that was, because what he read was basically his letter of October 11th.
I will find that.
Is there anyone else who wanted to speak in favor of the request to reconsider? Again, keeping in terms of what we've established.
Mary, I could take a look at that.
Yes, would you please? Thank you.
Okay. Is there anyone, I'm sorry, Louise, yeah?
Louise Lester, 10 Hartley Lane. I'm certainly in agreement with what David has said and what we have discovered over the period of the last 2 or 3 months. I just want to say that it's not conducive to the neighborhood, which we've already established, and that a great many of the people here in this room are here because of this issue and the fear of it happening somewhere else in Raymond.
Any questions from the board?
I'd like to make a motion that the board votes to whether or not to grant the request at this time.
Before we do that, we've been offered materials. These materials aren't the letter of October 11, 2018, but yet another statement, series of photographs, materials that this board hasn't considered, and really trying to enlarge the record, which a reviewing court might not understand later. Mr. Clerk, I recommend that we return that to the appellant. That's not... You may have been reading from portions of it, but that's not an exhibit for this board. Putting it in the record would only confuse things later.
Thank you. Okay, we have a motion on the floor.
Oh,
You
I
hang on
didn't.
1 second.
Okay.
Do you want to wait for 1 second to let her?
Sure.
I just have a
Hold that.
question. I'm not sure I understand. I thought I heard you say, sir, I'm not sure your name, the attorney, that if there was something that we couldn't have possibly known, we can bring that up here. Is that what I heard you say, or is that incorrect?
If there's information that could not, this is my advice to the board, if there's information that could not have been presented that might be relevant, then that's perhaps the reason why you might grant reconsideration. But
Information relevant to the...
relevant to the,
bullets that were brought,
This is what's been brought before the board,
yes.
for as being new information, and the board
That's
can make
only
its decision.
pertaining to the bullets the 2 bullets.
This
Because
was-
I guess you can tell me to stop talking if you need to, but the trailer has been delivered.
Okay.
That's
stop-
what I
hold-
wanted to-
Stop
okay,
for 1 second,
okay.
okay, please. Let me just try to explain this one more
Okay.
time. This is a legal process that we have to
Yes.
go through. So you folks filed your appeal.
Mm-hmm.
We had a hearing on that. It was continued, there was a decision. This is now a request to reconsider. This isn't a new hearing. This isn't for new evidence to be brought in, new issues to be brought in. There were two bullets that were given to us as the reasons why, or the points that were being focused on as to why we needed to reconsider. So if you have any information as to why you could not have known that these would be possible issues when you filed the original appeal, that's what we'd love to hear, if you have any information as to that.
I'm not sure if I even understand. Do you want to come up? Go ahead.
Jennifer Finney, 4 Canal Road. In reference to these 2 items, you asked if there was something that we didn't know. I guess I would like...
Couldn't have known.
Couldn't have known. Well, I would like to reiterate that these are state laws, local laws, and this board in this town is not following state and local laws. We're pointing that out to you, and during the previous meeting, you guys just kind of like passed it off and never really acknowledged it or talked to it. So we're bringing you these 2 points, and there is information that we have tonight that we did not know, and Scott did not know, that has a definite impact on our requests for reconsideration. And we're not allowed to present that to you, as Mr. Murch was cut off as he was trying to present that evidence that Mr. Katsifikis said we should be allowed to bring to you tonight. So I feel that in terms of due process, we are not having our say as residents of the town of Raymond. We were cut off, cut short, trying to present you with the information of why we want this reconsidered, which goes beyond these 2 bullet points.
Okay, thank
because
you.
of something that just came about.
Thank you very much. Thank you. Is there anyone else to speak? Are you speaking in opposition to? Okay, is there anyone else to speak for the request to reconsider? Okay. And no more questions, folks? Thank you. All right. Anyone that wants to speak in opposition to the request to reconsider?
My name's David Knights. I live at 5 Canal Road. I am in opposition to bringing this all back up. I feel that we've been long enough, that we've dragged it on pretty much all summer long. We've been here, we've been through all the ordinances and all the laws and everything that we feel that we have done what we need to do. And I just feel like at this point it just needs to be closed and just let us move on with what we're doing. I'm not a lawyer and I don't claim to be one. I just feel like it's been long enough, and I'm just want to let you know I'm in opposition to bringing all this back up. Thank you.
Any questions?
No.
Okay. If we have no other comments, questions from anyone here, we have a motion on the floor to take a vote regarding the request for reconsideration. we have a second?
Second.
All those in favor? All right, any discussion? And Len, since you made the motion, you can start if you'd like. Any discussion on your motion? Would you like to speak to your thoughts? And just quickly, I will say public comment then is closed.
Okay, I've read over everything 1,000 times, and I understand the 2 points that we were presented with today, but I honestly don't feel that there's enough there to change the board's decision.
Rick, any comments?
I pretty much agree with what Len said. I don't see a reason to reconsider. I really don't.
And I am pretty much in agreement as well. I understand frustration. I understand issues that you're bringing up. We do have a process that we have to follow, of which an appellant is allowed to bring an appeal. That's where you bring all of your evidence at that appeal. The appeal, we can't allow an appeal just to continue going on and on and on, and to restart an appeal. We did make a decision, and the legal process is from that decision on October 1st, you 100% have the right to appeal to Superior Court if you feel the decision was incorrectly made. And as far as the request to reconsider, I just haven't heard anything that has told me that these issues could not have been brought to the original appeal. And I think one of them might have even been brought up, but either way, I haven't heard anything. It may have been, you may not have understood it at the time, and I'm sorry if that was the case. But I don't see any reasoning as to why it couldn't have been brought. So we can't reopen and allow the appeal to continue on the same issues. So with that, do we have a motion for the request for reconsideration?
Yes.
Okay, so the motion, what's your motion, Lynn? And move to
My motion is to have the board ignore the request.
deny?
Deny.
Deny.
Yep. So we have a motion to deny the request for reconsideration. All those in favor?
Aye.
3, 0 opposed.
And the second was by Mr. Welch?
Yes.
Okay.
Again, as far as dates for the appellants, you had 45 days from the October 1st decision, original decision, to file your appeal with Superior Court if you so choose. Okay?
And I have a draft decision for you to look at
Okay.
and perhaps adopt this evening after you consider it. I'll have this ready for Ms. Quirk to print out in just a moment.
Do we need to take a short recess?
If we could for just a few minutes,
All right, we'll take a brief recess to have the decision in writing. To bring the October 29th, 2018 Zoning Board of Appeals back in session. I think Attorney Katsifikis is going to read for us the decision.
here's a draft decision. Ray, appeal of CEO building permit for tax map 47, lot 20A, 5 Canal Road, David and Tammy Knights. Request for reconsideration. This matter arises out of an administrative appeal dated and filed June 29, 2018. The appeal by Gary D. Vogel, Esquire, on behalf of Jen and Ron Finney, Thomas and Renee Cobb, Judy Sear, Christopher and Alyssa Trepanier, John and Joanne Taft, David and Anne Marie Murch, Louise Lester, Travis McClellan and Darcy Foley, and Alicia Irish, the appellants, from the Code Enforcement Officer's decision, June 6, 2018, issuance of a building permit to David and Tammy Knights for placement of a 14 by 70 mobile home and previously constructed 12-foot by 28-foot addition on a lot on Town Tax Map 47, shown as Lot 20A, 5 Canal Road, the lot. The Board of Appeals conducted a public hearing on June 30, 2018, and heard from Attorney Vogel, Ms. Lester, Mr. Murch, Ms. Finney, Ms. Trepanier, Mr. Knights, and Ms. Knights. Appellants agreed that the lot is a buildable lot of record, but alleged that the Knights' application is deficient and that a mobile home is not permitted on the lot. The Knights disputed these arguments. After closing the public hearing, the Board of Appeals began deliberations and unanimously tabled the matter to August 20, 2018 at 7 p.m. to allow the Board of Selectmen to provide information about the nature and history of the Town of Raymond Land Use Ordinance excerpt of District Regulation for Residential Development as of 6/11/2014, found in Attachment 3 to the appeal. Because the town clerk could not conduct the research and provide that information to the Board of Appeals in time for an August 20, 2018 meeting, the Board of Appeals did not meet at that time, but instead met on Monday, October 1, 2018. The town clerk provided a memorandum dated September 21, 2018 with a review of changes to shoreland zoning ordinance and land use ordinance pertaining to LRR1 and LRR2 to the CEO. The Attorney Vogel submitted a letter dated September 28, 2018, questioning the town clerk's research and the town clerk's October 1, 2018 response to Attorney Vogel's letter. The town also received additional materials and arguments from Mr. Murch on or about September 26, 2018. At the October 1, 2018 meeting, the board unanimously voted not to accept the additional materials and arguments offered by Mr. Murch, and by a vote of 3-1, determined that the application was complete with the conditions added by the board and denied the appeal. Mr. Murch now has filed a request for reconsideration, dated October 11, 2018, of the board's October 1, 2018 decision, the request which the board is considering on October 29, 2018. Findings of fact and conclusions of law. Maine Zoning Board of Appeals Statute, 30 MRSA Section 2691, allows for a person to submit a request for reconsideration within 10 days of the date of a Zoning Board of Appeals decision. The board's decision on the appeal was made on October 1, 2018, and according to Mary Quirk, was filed with the town office on the same day, and so the board finds and determines that the request filed October 11, 2018 is timely. Section 2691 sets out the process for reconsideration as follows. I simply went through the statutory requirements, the 3 paragraphs. With your permission, I'll skip those. The board has heard from Mr. Murch and others at the October 29, 2018 meeting. Mr. Murch, in his request and orally, offers 2 arguments in favor of reconsideration: that the Knights did not provide proof of payment of property taxes in the municipality in which their mobile home had been located before moving it to Raymond as required by state law, and that the Knights did not have a driveway permit from MDOT or a right to use the driveway to access the lot, so that under the Raymond Land Use Ordinance the building permit should not have been issued. This state statute and the ordinance provision were in effect at the time of the appeal. The driveway issue was addressed at length during the public hearing by appellant, and appellants could have provided this material at the original appeal. After hearing from Mr. Murch and others on the question of whether the board should reconsider its decision, the board determines that what is presented in Mr. Murch's October 11, 2018 letter is not new evidence that could not have been presented at the original July 30, 2018 public hearing. Therefore, on a motion by Mr. Sorelli, seconded by Mr. Welch, by vote of 3, Welch, Sorelli, Stinson, to nothing, the board votes to deny the request for reconsideration. So that's the proposed findings of fact and conclusions of law. So are there any things that should be changed in that?
No.
I move to accept the decision as written.
Right. And is there a second?
Second.
All those in favor?
All right.
Did you make a,
The only change I made was to insert meeting on that next to last paragraph, the first sentence. The board has heard from Mr. Murch and others at the October 29, 2018 meeting.
meeting?
Sorry.
I will add meeting.
Thank you. With that, they will be ready to sign.
All right.
I do want to sincerely thank all of you for coming tonight. I know you're working really hard on all of this, and I really wish you all the best through this process. So thank you. We have on the agenda next is Code Enforcement Communications.
We have another meeting.
Yeah.
So we have a gentleman that is going to, he wants to do a auto repair in the commercial zone, which is allowed but only through zoning board of appeals. it's a conditional use,
Okay.
so it has to go through you. One of the things they'll have to show is, do we have adequate parking for what he wants to do? But that'll be on our next agenda. So far, that's the only one that we have.
Where is that going, Scott?
That is going on, where the car wash is in
Yeah.
Raven? And if you're going from north to south, right before that, there was a big green building. There was some cars parked on there. Up
Auto
front
work?
there.
Yeah,
Yeah,
it used to be auto work.
yeah, he wants to go into that building.
Oh,
there.
okay.
I
He
thought
wants
we
to occupy 2 units.
Two units there? Okay. Thought we had a second one.
Um,
Setback
two.
reduction or something?
Yeah, there was a
Yeah,
setback.
yeah, Hayden Road,
Okay.
pre-existing. But they want to sell the house. In order to sell it, they got to clean that part of it up.
Oh, okay, okay.
It's just it doesn't cross property lines,
Yep,
but some of the building is a partial in the setback.
okay,
And that'll be the other one.
okay.
I don't know if they both came in at enough time.
Yes.
They did.
Yeah,
Okay, so we got-
Mary's got them
okay.
both on,
Yeah, well, good thing she's on the ball.
Yeah, we
But,
did request to have a site walk for.
yeah, you could, yeah, that's fine. I think if it helps you, even if it's not really so pertinent to that, but it helps you further down the road on something else, but I think it would be worth it. I mean,
Yep.
you get to see the age of the house, where it is, where the road is.
I think she scheduled it on the
Yeah,
17th.
17th.
What's the address? Because I'll just have to drive by because I can't make the site.
I believe it's 12 Hayden Road, but I can get that information to you, have Mary get that to you. But that's the actual, I believe it's 12 Hayden Road.
It is Hayden Brook Road.
Hayden Brook Road.
I'm mailing packages, I could have brought them tonight. I will be mailing packages tomorrow. It will have the maps, addresses, and also photographs, so you know what it looks like when you get there.
Okay.
'Cause I will be at the meeting, but I will not be able to attend the
Right,
site.
I had.
No worries, no worries.
So I need a copy for us.
Anything else,
a copy for, I don't know who's
I think
representing
that is it for upcoming. We may have another one next month, but don't know where
Okay,
that
I
one's
will do
going
that
yet.
then.
So
Okay.
Thank you.
Attorney Katsafis, thank you so much.
Thank you.
Appreciate it.
Take care.
Me too.
and one we averted and went to a site staff review of what he wanted to do, so it cleared up. He moved by doing that and moving the road over. He cleared up an issue because
Okay,
at the time it would have been he could have gone for a variance.
okay.
Good thing him and his brother are under good.
Oh.
They were able to move. They moved the road enough that it wasn't going to be a problem. So.
Good, okay. Any other questions, gentlemen?
No,
Do we have a motion to adjourn?
I motion to adjourn.
Second. All those in favor?
Aye.